Hi, everybody. I'm Brittany Lewis with Forbes Breaking News. Joining me now is attorney Mike Gottlieb. Mike, thank you so much for joining me.
Thanks for having me, Brittany.
You have had a really busy couple of weeks, so let's break it down. You represent Shay Moss and Ruby Freeman, the two former Georgia election workers who sued Rudy Giuliani for defamation. A jury ruled he now must pay them $148 million, and in the latest development on Thursday, Rudy Giuliani filed for Chapter 11 bankruptcy. What is your reaction to that latest development?
Yeah, it's been a busy week. The bankruptcy filing yesterday was not a surprise. It was, I think we were both anticipating that would happen and planning for it for some time now. I think there's some information that Mr. Giuliani included in his bankruptcy petition that is interesting new information to us. But the fact that he is filing for Chapter 11 protection is something that we were expecting for some time and planning for, in the sense of making sure that the judgment that we obtained for our clients would be a judgment where the debt would not be dischargeable. In other words, a debt that can't just be wiped out by the filing of a bankruptcy claim.
Can you talk about or give some details about what information was interesting and new to both you and your clients?
Well, I think anytime someone files for Chapter 11 protection, they need to list out, their assets and liabilities. And in their liabilities, you typically need to be pretty specific about who you owe money to, your secured and unsecured creditors. And so I think, for those who are following our litigation, we have been asking for quite some time for information on Mr. Giuliani's net worth and his assets as relevant to the issues in our case, the discovery in our case. We wanted to know, for example, what agreements or deals that he had with various networks for his radio show. We wanted to know the reach of his radio show in order to be able to sort of trace how far the defamation about our clients had spread. We never got that information. He refused to produce it. It's part of why the court sanctioned him and issued a default judgment. So some of the information in there is new to us in the sense of just understanding, taxes that he owes that he hasn't paid, obligations that he has to the government, and then sort of a list of all the other lawsuits that have been filed against him where there are potential claims.
I know you said you're not surprised by this news, and just a few weeks ago, Rudy Giuliani's lawyer said that a high payout is the, quote, civil equivalent of the death penalty. When you hear that, paired with the bankruptcy filing, what is your assessment there?
I mean, I think that's obviously what his lawyer was trying to foreshadow. Was without saying it, because saying it would be improper. Without saying that directly in court, he was effectively saying, if you give a large damages award here, it will bankrupt him. That's sort of what I mean when I said it's not surprising to us that he filed for bankruptcy. I don't think we thought that Mr. Giuliani had $148 million sitting around in a bank account, or had $148 million worth of assets sitting around. So it wasn't surprising to us when the judgment came out that he might seek bankruptcy protection.
Will your clients ever see the $148 million or even a fraction of it?
They're definitely going to see a fraction of it. I mean, we are, like I said, we've been preparing for this. We have pursued a judgment that is not dischargeable, which means our clients will still be able to collect on that judgment, and it won't be able to just be wiped out in a bankruptcy proceeding. And Mr. Giuliani reported having assets in his filing, and I think he even went on a radio program, or maybe it was his show yesterday or the day before, saying he's actually he's not insolvent, but for this judgment, and he's sort of said he has significant assets, but this judgment exceeds the assets that he has. So I do think our clients are going to see money, but I think to just take a step back for a moment, there's something far more important about the judgment, and it is that the judgment is vindication for our clients, and it also sends a message to, I think, to others out there, particularly in our sort of current political and media climate. It sends a message that if you go out and take advantage, if you're somebody with a large platform, a large audience, somebody like Mr. Giuliani has been, and you go out and you target to sort of ordinary Americans, civil servants, and defame them and make them the face of fraud or crime in order to win an election or score political points or do whatever in order to make yourself more famous, there is a real cost to that. And I think that message is part of the importance of the verdict. And I also think that for our clients, sending the vindication that they have significant worth, that their reputations have value, even though their income bracket was not, the upper income bracket when they started all of this litigation. I think that's an important message to be sent. It's an important victory for both our clients and for the rule of law generally.
On a more personal note, how are your clients doing? Do they feel this vindication? Do they wish this never happened? Are they happy about the price?
They definitely wish this never happened. I think either one of them in a heartbeat would trade the vindication and whatever money they see out of this, would trade all of that to be able to go back to the lives that they had before December of 2020. No question. Their lives have been completely upended. They don't get to have the lives that they chose for themselves, that they built for themselves anymore. Those have been taken from them. So there's no doubt that they would go back, if they could go back in time to before December of 2020 and continue to lead the lives that they were living, they would do that for certain. That said, they do feel vindication and validation from the jury's verdict. They do feel heard, and they got an opportunity to litigate this case. When you litigate a defamation case, one of the defenses to it is substantial truth. So the defendant can come in and defend the action and say, I'm not liable to you because what I said was true. And they have incredible powers given to them in doing that. And they can subpoena, they can issue subpoenas to third parties. They can put your clients on the stand under oath and ask them questions at depositions. And so for somebody who, claims that what they're saying is true, they have a lot of opportunity to prove it, right? To show up in court and prove it and provide documents and unearth the evidence and put it all out there in the record. And then the court or the jury can decide whether the person's statements were supported by the record. And so part of why our clients feel such vindication through this is that there was none of that. At no point, Mr. Giuliani has been out saying he didn't have a chance to present any evidence. That's just a total fabrication. Throughout the entire discovery process, he had subpoena power. He could have issued subpoenas. He could have deposed our clients and put them on the stand under oath. He could have subpoenaed evidence from State Farm Arena, from Georgia election officials. He could have brought in people he claims were eyewitnesses that he claims exist. He could have brought forward the video evidence that he says exists of our clients, according to him, passing around USB drives. Any of that, he could have used subpoena power to acquire the evidence, bring it into court, and prove that what he said was true. He brought nothing into evidence. He chose not to participate. He defaulted. He didn't turn over documents, and that's led us to where we are. So long story short, I think our clients feel a vindication and validation that they were able to tell their story. They were able to tell it publicly. They did so under oath. They did so, under cross-examination from Mr. Giuliani's attorney, and the jury sided with them.
Can you bring us into the courtroom? What was it like with you, Shaye Moss, Ruby Freeman, in the same room as Rudy Giuliani?
Yeah, and I should say it wasn't just me. It was, me and my co-counsel, both from Wilkie Farr, but also from Von DuBose from DuBose Miller, and John Langford from Protect Democracy. Had a great team that litigated this case from the start. So it was not me by myself. But it was at times surreal. because Mr. Giuliani was in the courtroom with his spokesman or assistant or Ted. I'm not sure exactly what his title is, but Ted Goodman was there with Mr. Giuliani, and they were, while the proceedings were going on, they were actively planning out their sort of nighttime media strategy and what shows they were going to go on and what they were going to go say to the cameras afterwards. So we were sort of watching, a trial that was underway with witnesses coming to the stand under oath and putting evidence forward, and then watching sort of a communications or media strategy taking shape in the courtroom that would then be executed that night when we all left. So it was a little strange. I think that's the first time that Mr. Giuliani has been in the same room as Ruby Freeman and Shay Moss, and so I think there was some power in that for our clients, in the sense that they were in the same room and Mr. Giuliani had to sit and listen to the testimony of both our clients about what happened to them, but also the Georgia election officials who explained why everything Mr. Giuliani and his co-conspirators had been saying about our clients was false. So I think there were some powerful moments throughout the week of where witnesses would come in and testify and explain exactly why what had been said about our clients was false. And so I think that was important in terms of creating a historical record of what occurred in December of 2020.
I know it must have been a whirlwind, but looking back now and reflecting, what was the most powerful moment to you?
To me, it was, there were many in the trial, and I'm tempted to say it was the testimony of our clients, Ms. Freeman and Ms. Moss, because it was just the courage that I think it took for them to take the stand and to open themselves up to cross-examination and questioning, and to relive these vile, just horrible threats that they received in voicemails and text messages that were played in open court. We had the actual voicemails from their phones, played them in open court for everyone to listen to, had the text messages that they got. So I think I'm tempted to say that, but really I think for me the moment was when the jury came out and announced its verdict, because I think that verdict was a message about the worth, the value of Ruby Freeman and Shay Moss's reputations, right? It was a signal that their lives, their reputations are worth just as much as a celebrity or a billionaire's life or reputation is, and that's not the worth of their reputations and lives shouldn't be discounted because they were election workers in Georgia. They should be compensated based on what happened to them and how harmful and devastating the conduct was to their reputation. So to me, when the jury read that verdict, it was a moment where everyone in the courtroom sort of could simultaneously experience real accountability and a real moment of accountability and justice.
When you heard that number, because I know I've been following the case, when I saw that number, I thought I misread it because it was so large and it was way higher than anticipated. Were you surprised when you heard 148 million?
Was I surprised? I'm not sure I was surprised. I think there was some misunderstanding in the way our request for damages was reported. And so our request for damages was frequently reported in the press as though we were only asking for reputational damages. And so we had a range that our expert was prepared to testify to for what the reputational damages to our clients should be. And that was the sort of range that was being reported on, as you saw in the press, saying Ms. Freeman and Ms. Moss are asking for up to $47 or $48 million or something like that. I think what that left out was that we weren't asking for a specific number for emotional distress damages, and we weren't asking for a specific number for punitive damages. We were leaving that to the jury's discretion. And I think that I always thought that the jury might while award a greater number for emotional distress damages based on what happened to our clients than for reputational damages. I think we had excellent expert testimony on reputational harm and a method for measuring and understanding, quantifying in real numbers reputational harm based on the total number of impressions caused by the defamatory statements that Mr. Giuliani made. But for emotional harm, the jury really had to relive for a week what it was like to be Ruby Freeman and Shay Moss, starting in early December, and getting people showing up to your house trying to perform a citizen's arrest on you, people harassing your grandmother, having your 14-year-old son who's at home trying to go through remote virtual school during COVID, having him kicked off of his classes because of voicemails and calls coming in that are threatening calls, just using vile racist language, talking about hanging them in the trees in front of their house. Statements like "Be glad it's 2020 rather than 1920." These were real messages, and I know that there's been some. I've seen some shows that Mr. Giuliani has gone on where commentators have suggested, well, what are these threats really? Or how could they really be that bad? Anyone who sat in that courtroom and heard the actual voicemails and saw the actual text messages and saw the emails and saw the handwritten letters with drawn pictures of like racist demonic figures in them that were sent to their house, those people understand. Anyone who sat through that testimony and saw it, or even anybody who just has looked at the record that's been made available publicly now, understand what our clients went through and understand how horrific it was. So all of that is a long-winded way of saying I wasn't surprised that the emotional distress number was larger than the reputational damages number. And then, for punitive damages, Mr. Giuliani went out. Punitive damages are meant to punish rather than to compensate. So they're aimed at the defendant rather than the plaintiff. And, Mr. Giuliani left the court the first day after everyone in the court had heard these voicemails. They'd heard the voicemail, they'd seen videos, they'd seen all the evidence of the threats that followed the day after Mr. Giuliani went out and publicized these statements about our clients. And he went out on the courthouse steps and gave a little impromptu press conference and said, "I don't regret anything. I regret none of it." So after he said that, I was not surprised that the jury returned a large punitive damages award. I thought it could have even been larger than that.
I do want to break down the number in just a second, but I saw that press conference. I'm sure a lot of our viewers saw that press conference of him doubling down on those defamatory statements, saying, "I don't care," not showing any remorse. Was the Rudy Giuliani we saw on the steps and on different nightly programs, was that the same Rudy Giuliani that was in the courtroom that you saw?
Yeah, it's the same person. I mean, it's obviously he didn't take the stand. So he chose not to get up and try to explain himself. He didn't testify, even though he had the right to do so if he wanted to. So we didn't never hear him sort of speaking directly to the issues in the case, but we could hear him talking, muttering, talking during the testimony. And I know that there were members of the press sort of watching more closely than I was because I was focused on the witnesses and the jury. But I know people were watching what he was doing and what he was reading in the courtroom. And it seems to me anyway that the person you saw giving that press conference was sort of the same person sitting in the courtroom.
So let's break down the $148 million here. It's more than $33 million in damages for defamation, $40 million for emotional distress, and $75 million in punitive damages. What precedent is this setting, do you think, especially as we are about to head into an election year?
So I think the message that it sends is that there is a real price to pay for leaving it. You've asked me the question in the context of an election year. So in the context of political, sort of these political conspiracy theories, right? That some shadowy forces out there are actually responsible for an election being stolen or an election being rigged. I mean, if the message it sends is if you accuse civil servants, with no evidence of engaging in stealing an election, whether it's people who are processing ballots, or people who are working at a polling station, or people who are sitting on local election boards, these civil servants who are vital to the functioning of our democracy. Our elections can't work without them. And I think the message that this sends is that if you do that, you may pay a really steep price for it. And there are people who are willing to stand up and hold you accountable, and the judicial system is equipped to see those cases through and to provide real compensation for people. So I think there's probably been a sense over the years that these kinds of people, these sort of ordinary people, as they were referred to in the case, that they're sort of expendable, and that you can get away with sort of scapegoating people, or pretending that you have evidence that these people have done something. I hope the message that this sends is that you're not going to get away with that anymore. That there will be a real cost, there will be a real consequence, and that people need to pay attention to facts and what the evidence actually shows. And anybody who was listening to, the Gabriel Sterling, or people from the Georgia Secretary of State's office who were, led by an elected Republican at the time, in early December of 2020, were saying these videos don't show fraud. They show normal ballot processing. People were not kicked out of the arena. Ballots were not counted multiple times. If you understand how our systems work, you would understand what was happening was not abnormal. It was not unlawful. And the people who were counting ballots at State Farm didn't do anything wrong. They were being told that in real time. So I hope the messages we'll send is to listen to those election officials when they're providing explanations in real time.
Before I let you go, I do want to ask a question on a personal note. The judge in this case ordered Rudy Giuliani to pay around $130,000 in attorney's fees. So are you personally waiting on money from Mr. Giuliani?
It's more than that, actually. It's more than the 130. I've forgotten what the total is at this point, but not really. I mean, my firm, Wilkie, Farr and Gallagher, took this matter on pro bono and has provided. The firm has really been incredible in the support that it has provided to litigate this matter. We're mostly focused on, or chiefly focused on, getting our clients compensation, and not losing too much sleep over the fee awards that Mr. Giuliani has decided not to pay. Again, we hope that those fee awards will serve as a deterrent to others to understand you have to comply with your discovery obligations. And if you force us as lawyers to have to file a bunch of motions, discovery motions, that we shouldn't have to file if you just followed the rules and played by the rules of litigation, we'll seek fees. I think that's an important message to send. But the thing that we're focused on is getting compensation for our clients.
Attorney Mike Gottlieb, thank you so much for your time, and congratulations on the verdict.
Thanks so much, Brittany. Thanks for having me.